was driving, I did consume a beer at the bar. Yes.
Okay, and did the consumption of that beer impair your ability to safely operate that motor vehicle?
Yes.
Mr. Moore, you cannot answer for your client. Now, first of all, nobody's going to make me believe that the consumption of a beer impaired his ability to operate a motor vehicle. So we're going to go back. We're going to dial it back. Otherwise, I'm not going to accept this plea. And we're going to... And we're going to either tell the truth, the whole truth, and nothing but the truth. And if that is the truth, because it's possible that it's the truth, that he drank one beer. Okay, listen to it's possible that it's true that he drank a beer, but it's not possible that that beer impaired his ability to operate a motor vehicle. Now let's go back again. What did he have to drink before he operated the motor vehicle?
I had a beer. I was at the bar watching the game.
All right. I'm not going to accept I'm not going to accept the
ma'am.
plea.
Your Honor.
I need you to let me do my job.
Okay.
I'm not going to accept the plea. I need discovery to be sent over to Mr. Moore. I need to see what his alleged blood alcohol was after he consumed the beer. And then we're going to look into it from that perspective, because I've never in the history of my life known a person to be impaired after consuming a beer. Okay?
Yeah, okay, ma'am.
Let me tell you this, sir. Don't keep talking to me.
Okay.
Yeah, I have that discovery, and I reviewed with them that the results were 0.166.
Well, then, if that's the case, then your client is lying on my record. So let's be clear.
Okay.
If that was his blood alcohol level, then your client, under oath, I swear to tell the truth, the whole truth, and nothing but the truth, so help me God. If that is his blood alcohol level, then your client is not telling the truth on my record.
Your Honor, I'm going to say this. Okay.
I don't understand why there's conversation with me and your client while I'm trying to take a plea. That's what I don't understand. Now, the question was asked, what did he have to drink? Your client said he had one beer. So either there's something, the math isn't mathing. Something is not right. And I'm not going to just take a plea for the sake of taking a plea. Either he's guilty or he's not guilty. But if he's not guilty, then I'm not taking a plea. We're not, no.
Sure. Well, that's what I talked to you.
So do we want to go back to what did we have to drink? I mean, I don't know.
Yes. Tell me yes.
He said yes. You got to tell her what you had to drink.
Okay. I had more than one beer, Your Honor.
Ms. Ritter, you can continue.
Thank you, Judge. Mr. Hunt, and did the consumption of those alcoholic beverages impair your ability to safely operate a motor vehicle on that day?
Yes.
And Judge, for purposes of the plea, the people stipulate to the blood alcohol content of 0.16, and with that, the people are satisfied.
I'm also satisfied, Your Honor.
Let me tell you all something. if I'm not serious about anything, I'm serious about two things. One of them, they don't let me discuss in my judicial role. That's my number one thing that I care about. The thing that they tell me that I have to separate. The second thing is I take this job, this courtroom, and this process seriously. Now, what I could do is have Mr. Hunt charged with perjury, but I won't because maybe he was a little confused. But what we know is that he lied today on my record under oath. What we know is, looking at Mr. Hunt, a child could drink a beer and not have a 0.16 blood alcohol. We're not even talking about a 0.06. We're not talking about a 0.08, barely the legal limit. You sitting up here telling me it's a 1 in front of his number, and he got on my record under oath and said all I had to drink was a beer. That's insulting to the court. Your credibility is shot. And it's clear to me that at somewhere in your life, you living in a denial. You living in a denial somewhere. Now, I don't know if you drank a beer and the glass was as tall as you. But if you're going to tell me you blew up, what was the blood alcohol?
0.16.
You blew a 0.16 after you drank a beer. You shouldn't drink nothing else in your entire life, because clearly your body processes the alcohol different than everybody else's body that's alive.
Understood, yeah. I didn't do a good enough job prepping him.
You don't have to prep somebody to tell the truth. You don't have to prep somebody to tell the truth, the whole truth, and nothing but the truth. You don't have to prep them. You don't
I
have
should
to
have been
prep
more emphatic,
them.
man.
You should have, but he should not have lied.
I
Don't
feel
come
like
on
he's
here
been
lying. Don't come on my court lying. Don't come on here lying. All right, court is satisfied with the factual basis as well, and I will accept a guilty plea to 1 count of operating while visibly impaired.
Thank you.
You're welcome. The court is going to set the matter for sentencing. Mr. Flanagan, November 15th. How do I look?
Just 4 matters.
Court is going to set the matter for sentencing November the 15th. At 9:00 a.m. Sentencing is going to be in person.
Understood.
Put it on my docket, Mr. Flanagan, for 9:02.
Okay.
Prior to the sentencing, Mr. Hunt must submit to a pre-sentence investigation and a substance abuse evaluation through the probation department. Probation is going to contact you by telephone. If they cannot reach you, they're going to leave you a message and mail you a letter directing you to contact them. You must submit to the pre-sentence investigation prior to your sentencing. so that I can have a proper pre-sentence investigation on the day of your sentencing. Bond will continue with no drinking and no driving without a valid license. Anything further?
No,
thank you.
no, Your Honor.
All right, we're all set. Have a great day and stay safe.
Thank you again very kindly, Your Honor.
You're welcome.
By the state in August, and says we sent. You know. The automated certificate of service here states it's going to Sonia Gordon. Who's that?
That's our secretary.
Oh,
If you had
okay,
Mr. Adams.
sorry.
When you want to even add it on to it?
Not yet. He just. Just leave that. Keep on the Washington.
What does that mean?
No attorney is. So I can do it. I just want to add me to him.
Well, you are an attorney now, right? No, yeah. Did you? Well, there's a
I think
motion.
that's why there was no service to him, because it didn't show him.
No, I haven't been. No, he's never hired me, and I think y'all was gonna court appoint me. They haven't court appointed me yet. See what I'm talking about?
Well, if he's unable to hire somebody,
Mhm.
financially he needs to fill out an indigent form first.
Fill out one. Hold on.
But there's a motion to increase the bond, so we got to deal with that. We can't.
I'm looking. They don't show you as attorney.
Right. That's what I was thinking.
Yeah, this is very disturbing. I hadn't read that before, but it's a very disturbing allegation.
But Judge, if you, I don't mind helping. If you point me on the case, I can get, and just give us a reset that way.
He's not leaving here. He's not leaving without a bond. We got to deal with the bond. And I mean, it says he is contacting the victim, holding the children hostage in an effort to get, you know what? Sit over there. Okay, sir?
Is he in custody?
Yes, he is in custody.
He just said she's outside. You mind if I have a moment to go talk with her?
Yeah. Yeah, but the bond condition is you shall not have contact with the victim. That's his burden, not her.
He's right outside.
We have a sentencing here.
Yes, it's sentencing.
You find it, Amelia?
I spoke to her. She's not here. She's at home. Evidently, Mr. Ham didn't notify her to be here today. But she has recordings and everything. Someone need her here for testimony and she can't get here right now. So I told her we'd reset it for, if we could, for a week, please.
She's still moving forward.
Yes, she's still coming. She said she'll be on. Because according to her, he's holding her kids hostage over this situation. So
Well,
we're gonna take care of it next week, Judge. I can't produce any evidence today other than what I talked to complainants about.
we're gonna have to do something though, by phone or something, because I'm going to, his bond
Yes,
is
sir.
revoked and he's gonna be put into custody immediately, but I can't do that without something verifiable on the record.
I have a good number for it, so we can call him over.
Okay, that's what we'll do. And you are Mr. Palmer, right? Okay. 21-387-11 is now called. And you were here with John West, your attorney.
Last hearing, we pled guilty and we get some affairs in order when he goes to custody.
I'm gonna need the Mr. Pad, please.
Do you know what David pled?
It would have been 8/16.
Probably. Agree.
Yeah.
We just been talking right
I didn't know if it was something like it.
David Rice, David Rice, yeah, ERA.
But they expect you to do that. It was not. Logs and JD, you know, right.
I pulled up for you, Judge. Right.
And again, you are Herman Palmer in 21-38711 with your attorney, Mr. West is present, and the state's attorney. Earlier, you entered a plea of guilty to this indictment of a state jail felony burglary of a building. And that was done earlier, it looks like on August 16th, last month. We reset this case for sentencing. And the pre-sentence report was waived. And is everyone ready to move forward? State?
Yes.
And you, sir? You have to speak up.
She's got to take it.
Okay. All right, Mr. Palmer. Anything else to add? No?
From us, right?
No, sir.
All right. If nothing further to add, I'm going to find as follows that earlier, sir, you have pleaded guilty to the state jail felony of burglary of a building. In this case, voluntarily, knowingly, intelligently. There was sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted at the hearing to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of the state jail felony. I am following this agreement everybody's entered into, and you are hereby sentenced to confinement in the state jail for 18 months. You will, of course, be given credit for all time you've served on this. Anything else? That is all, sir. Thank you.
For you.
I'm looking at this pad and we have a dismissal dated today on Kiat Pham, PHAM in 22-40661. I'm signing that. That case is dismissed. What page was that?
Yeah.
That James Macon was the lawyer on that, by the way. Great job, James, getting that done without being present. Impressive. Got that dismissal and you were in another building. Your spirit.
Really?
Yeah.
Your Honor.
Same reason. Same reason. You're Brandon Seminary?
Yes, sir.
Your Honor, this is, we set this for trial a couple of weeks ago. It was set for trial 3 weeks ago, 2 weeks ago.
John, there's a motion to increase the bond.
Oh, have, well, let me get to my
And
point.
it's same thing as you heard earlier.
But I got to get to the first part, Your Honor, because we started the trial and it turned out that it appeared that, or not appeared, we confirmed that I actually represented the victim in the past case. So we had a mistrial because I could not move forward with that.
Okay.
So we need to appoint another attorney. So I can't even handle that hearing on that issue because I conflicted out because I apparently represented the victim before. So
All right.
I need to get another attorney.
So number one, you have filed a motion to, were you appointed?
Yes, it's part of, yeah.
To to recuse yourself and be be replaced with another attorney because you have a conflict of interest.
Yes, we found that conflict out after we picked a jury before we actually started the testimony. We discovered that me and Mr. Ham, and we asked for a mistrial based on that.
The next attorney on the trial docket will be appointed to represent the defendant,
Yes.
and I'm presuming this is going to go back on a trial.
But
But the problem we have here is we've got a motion to increase bond that has to be dealt with. And until we deal with that, you're in custody. You were in custody. There's a motion that's been filed that states that you have been having contact with the victim, which is a violation of your bond condition, and witness of the alleged offense, and that is a request by the state to have your bond revoked and then increased. And in all cases, it's set in stone that a condition of bond is that you shall have no contact with the victim of this case, according to the prosecutor here, who's not here. Well, another prosecutor's going to step in. These are serious infractions, if true. But here's the problem: is that until we can get this sorted out, you're in custody. Your bond is revoked. We're going to have a hearing as soon as possible. Did you say you were appointed?
yes,
You need to fill out another indigent form right over there. Sit down. You're going to fill out an indigent form. If I declare you indigent, then another attorney will be appointed to represent you.
all right, am I released off the case?
Well, is there any reason that you shouldn't be?
No, I think legally I need.
22-39623 is now called the State of Texas versus Braylon, right? You were Mr. Wright?
Yes, sir.
Present. Your attorney now, Terrence Allison
Yes,
is the attorney of record, but I know you're associated with Mr. Allison.
I am.
And you are, please tell us, present yourself for the record on the defendant's behalf.
Meridius Allen, MARIDIOUS.
Okay.
And do you understand, Mr. Wright, that Terrence Allison is not here? You don't have
Yes,
any
sir.
objection
Yes, sir.
for his associate to be here with you, who is a licensed attorney at law?
Yes, sir. Yes, sir.
Okay, you ready? Earlier, you pleaded guilty here in this case to the second-degree felony of aggravated assault. Pre-sentence report has been prepared. Have the parties had an opportunity to review it, and are there any corrections or changes to it?
I've had a chance to review it, and I'm not sure it would be a correction, but context of the defendant's version. He was asked what happened the day he committed the offense and stated I was locked up. And then goes on to say that did not elaborate any further. I believe it's a misunderstanding of what happened when he was arrested and detained. And that would make sense that he was locked up. He didn't provide any further elaboration on it. And I guess there was miscommunication as well, because I did ask the probation office to let me know when the PSI was scheduled to happen. And
What are you saying?
I was
You're not ready or?
ready.
Oh, okay.
I wish I was
Oh,
present during the interview, because that would have been something that could have been cleaned up at that time. But then as well, juvenile history, this was a school fight. SRO officer probably cited him. We know how that goes. It's nothing that was truly a reflection of who he is today. Of course, we're here on a serious matter, but just want to provide context to that as well. Then for the employment history, he was full-time employed with the city of Beaumont, the water department. We entered the plea of guilt a month ago, 2 months ago. They found out about it and let him go. So up until the plea of guilt, he was fully employed. But other than that, I am okay accepting the report as is.
Okay. What's that saying?
We have no corrections or.
All right, then it's made a part of the record. And the agreement is whatever sentence shall not exceed a cap of 10 years, so. We know what there are several options there. Regular probation is not one. Deferred is. And then flat time, no less than 2, no more than 10. I don't think there's another option.
Not that I'm aware of.
Go ahead. Defense, you may go first.
I would like to call the mother, if that would be an opportune time of this
Go ahead.
opportunity. Ms. Catherine Fox. We just want her to step to the side of him or? Okay. Hey, Ms. Fox, maybe sworn in.
Who is this now?
This is the mother.
What's your name?
Catherine.
Did you get that? Okay, raise your right hand. You solemnly swear or affirm that any statement you make today will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes,
Ms. Fox, you understand what your son has been charged with?
yes,
Aggravated assault with a deadly weapon.
yes, sir.
And his upbringing, were you mostly the parent to take care of him?
Yes, sir.
Okay, and as of today, are you been his main area of incomes or advice and all that jazz?
Yes, sir.
Okay, and can you just provide the court with some kind of context of who Bryant Wright is, his character?
Yes, sir. Reagan, he's my baby. He's the youngest of 3. I've been solely, the only parent, the dad, not allowed to want anything, to do with him. I've done the best I can with raising him, trying to keep him away from the streets and all of that that's going on. But
How's that working out?
it's doing well since this.
Here he is.
Yeah. And everything I told him, didn't listen.
And since the incident that took place, has he kept a straight road or has there been?
Oh, yeah. I think, I honestly think it scared him straight. I mean, he's at home, he's not running in the streets, and I think this is an eye open that, can't go around doing things and not be able to accomplish.
And understanding the seriousness of this offense, he is looking at 10 years possibly, with the great state. Of course, you're the mother, you love your son.
I do.
Well, what would you think is the recommended punishment for this offense?
I mean, as his mother, I would say, less time than that. I don't really know how all of this works. So, I mean, who wants to see their kid go to prison?
So it could be 2 to 10, or it could also be probation. And you understanding who your son is, what would be best for him?
I mean, I would say probation. I mean, he's not a bad person. I mean, I think if he was constantly here for, a whole lot of cases and, I would say something different, but I would say that probation.
Ma'am, do you understand or do you know any of the facts of the case? What was going on out there?
I found out some of what was going on.
What do you think happened?
When I found out
What do you think?
what I think happened, honestly, I don't really know.
Okay.
I really don't know. I just know bits and pieces of the case.
Well, you weren't there.
I wasn't there, no, sir.
So you don't know that there were 12 shell casings recovered your son fired 12 shots at this person.
No, I did not know that.
No, he was shot twice. Two bullets went into the person.
No.
You didn't know that?
No, sir.
There's a lot you must not know about your son.
I don't have any further questions of Joe.
What are you asking for? Yeah. Here. What are you asking for? Is probation or?
Give him probation with an understanding of the low risk assessment that was provided by the probation's office and lack of previous criminal history. Full-time employment.
Anything you want to say, sir?
I would like to say, I know my action wasn't right. And if you find it,
Which part?
my action as in my case, my aggravated assault with deadly weapon. I know what I did wasn't right.
What did you do?
Shot somebody. I shot somebody.
What did you think was going to happen when you shot 12 rounds at somebody?
I wasn't trying to hit him.
You hit him twice.
I know, but I wasn't trying to. If that makes sense.
All right. All right.
He was just out of anger and rage.
Over a $100 bet.
Yeah,
You're going to shoot someone 12 times because you lost a bet. Is that what this world has come to?
no, sir.
No. It's what your world came to.
Yes, sir. But if I
Well,
can,
that's what you are.
yes, sir. But I don't think that justifies who I am as a person.
Your actions do. Like mine, like his, like all of us. It's not
Yes, sir.
what we think we are or what we try to portray ourselves to be. It's the choices we make or our character determinations.
Yes, sir.
You made a choice to attempt to kill someone. Shooting 12 times at someone and shooting them twice over a $100 bet. Made a bet on a video game. You lost the bet for whatever purpose. You sent a text message to the victim stating you were on your way to pay him. You sent a second message telling him, come outside. So he goes outside, and this red or maroon four-door vehicle that you were in the passenger seat of and somebody else was driving, you fired 12 times at the victim, who sustained gunshot wounds to his left knee and his right calf. And he was in a wheelchair here at the time that this probable cause affidavit was prepared after he went to St. Elizabeth Hospital. But the point of the matter is this happens in the middle of a residential area.
Yes, sir.
So you come in shooting the town up when everybody's trying to live peaceably, and you are making a mess out of everything. So much for peaceful life here in Beaumont, huh? No wonder we get such criticism publicly, called the most dangerous place. When it's not an evil town, but there are people making it evil.
Yes, sir.
With bad choices.
Yes,
You
sir.
don't drive through a residential area and just shoot 12 times over a $100 bet and think you're going to scamper out of here with just a slap on the wrist. That's terrible.
Yes, sir.
There's no appreciation over the sanctity of life of another human being. His life is worth you losing a $100 bet. That's what you think.
No, sir.
Yes, what you did, sir. Your actions speak for your intentions. I don't think you were reared that way.
No, sir, I wasn't.
Well, then your mother has Jekyll and Hyde in her house. Which one are you? You're playing both sides, but you can't. You can't be evil and good. You've got to pick a choice. But you made a choice that night. And 12 rounds at someone in the middle of a residential intersection, a residential area in town, disrupts everybody. Can you imagine all the people who had to deal with that? How threatened they feel, like their home is not a safe place because of people like you? Over $100 bet? That's what life is worth to you, sir? Well, when you shoot 12 times at a human being, you intend to kill them, especially when you hit them twice. He's just lucky you're a bad shot. But that's about it.
Yes, sir.
Shame on you for that. That's not what But it's actions like yours are what makes the front page and what people think our area is all about. When we have good people who are struggling to try to keep the image of this area worthy of all the opportunities that are available with people who can make $40 an hour jobs right and left.
Yes, sir.
Not you. You're busy messing up in another way. All you got to do is get an education, get a trade, and you're making six figures.
Yes, sir.
And not going to prison.
Yes, sir.
But you have a choice like everybody else. And I don't understand how one after another people decide they want to get a gun, get the drugs, and shoot it out in the middle of the streets. No, we're going to get law and order. It may be one step at a time, but this area is worth saving
Yes,
from
sir.
people who act like you. And it's terrible. You ought to be ashamed of yourself.
Yes, sir, I am.
Well, here's the problem with shooting somebody. You can't take the bullets back.
Yeah, okay. Yes, sir. I know.
All right. Anything else? Anything?
Judge,
You know where I'm headed. I don't like this. This is bad. This is representation of bad acts that are not allowed without severe consequences on this court's watch. We can't allow this. He's not going to scamper out of here with, oh, I can do this and get probation. No way. No, he's going to be held accountable.
I just
We're
want to say
lucky.
I was not
The
there.
others weren't injured.
I was there. I was not there that night.
No.
It's a serious matter. But since I met him and worked with him, he's been on time. There are appointments for conferences. He had full-time employment with the city of Beaumont. Showed up to work, went home, stayed out of trouble. And as I'm aware of today, there wasn't any violations of his bond conditions.
How do you explain his conduct with all of that? His actions speak louder than what we're talking about. He can do that. He can do that 99% of the time, but if 1% he's shooting at people in the middle of residential areas over a $100 bet, I'm sorry. All of that kind of is a wasted effort when he can't have it. He can't say I'm 99% going to be good. I'm a 99% good person. It's that 1% that I put people in harm's way and shoot people.
I'm speaking to the rehabilitation. I understand that from the punitive standpoint that he should be punished within the realms of law and order. But in terms of how can he be rehabilitated from the actions that he took, of course, he could have killed someone that night. And he did hit someone twice. And he had to go to the hospital and everything like that. But
So the message then you think I should send, you put him on probation and everybody gets to shoot once at someone and put him in the hospital, shoot 12 times in residential areas, and you get the Draylen Wright rule. They get another chance. What's fair for one is fair for all. No, not on my watch. He's stepped way over the line on this. And he's lucky. He should be looking at 20 years. And actually attempted murder is another crime that could have been charged. Because that's what it is.
Yes, honestly.
My God, you would really attempted to murder another human, one of God's creatures.
Can I ask you a question? Judge, your mind.
Go ahead.
So if the belt was on my side, I'm asking like, what if I was in his shoes and he was in mine?
What are you trying to ask?
I'm trying to ask you is,
What?
I know what I did was wrong, but
Okay, so what are you trying to ask now? Well, I don't understand this at all. Are you saying $100 bet justifies attempting to murder someone?
no, sir, no, sir.
All right, then I'd stay quiet because logic is not working for you. You're not using logic, right?
You're right.
Anything else? If nothing further, I'm going to find you have pleaded guilty voluntarily. You are mentally competent to do so. You understand the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted during your plea hearing to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt. And I'm following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years. There will be an affirmative finding that a deadly weapon, namely a firearm, was used in the commission of this offense. I wish for your family, who obviously is a role, this lady is certainly a role model.
Yes, sir.
For actions that you defied to take. You
Yes, sir.
should have acted more responsible. You shouldn't have been hot-headed.
Yes, sir.
And you shouldn't have taken a firearm, shot at a human being, shooting him twice in the middle of this city in a residential area and shooting 12 times.
Yes, sir.
Peace went right out the window with you.
Yes, sir.
And we're supposed to be living together peaceably. And we are not going to send a message that when you lose a $100 bet, you get to go shoot and attempt to kill somebody. No, we've got to be clear-headed. And we're going to be held responsible when our actions are that foolish.
Yes, sir.
I wish you would have done something differently.
Yes, sir.
Anything else? That is all. All right, on Todd Robertson, Mr. Burbank's, Mr. Burbank is in trial.
And we're still completing discovery on that one. Leaving the scene did not involve intoxication. I think it's important to point that out.
How do we know?
Well, because he didn't
Would you be
really,
the same?
well, no, he really didn't leave. I mean, he left 2 blocks and he
There was contact with him that
Immediate.
evening.
Well, very soon. I mean, just 2 blocks down the road.
Yeah, June 28th was an interesting night.
It was, Judge, and there's some mental health issues that have been addressed with that.
All right, before he leaves, let's make sure he's lucid in his system. And we'll reset how much time?
Just the regular reset in months.
4 weeks? Okay, thank you. Hold on, Walter Walker.
Walter Walker.
Say that fast.
Walter
5
Walker
times.
3 times.
Yeah.
Walter Walker.
Do you need this? There's a question mark next to your name, which I've always thought should be there.
Right. I'm co-counsel. Co-counsel. I believe you were busy with that in dockets, but Judge, when I gave my CLE about the hemp bill, it is now legal for stores to sell marijuana.
Sure.
And marijuana is for sale all over the city of Beaumont.
He tested positive for marijuana.
Right, which is illegal in the state of Texas.
Marijuana is now legal in the
Yes.
state of Texas, 100%? No, it's not, sir.
Well, it is not.
No, it's not.
If it meets a certain threshold.
Okay, that's going to be your burden because he's tested positive for THC, and we're not going to open the door for everybody to show up high because they're saying, oh, I got this. This has got to be legal marijuana.
Well, but there is legal THC in the city of Beaumont. That's all. I'm just trying to point that out. The conditions of bond states that he cannot break the law, but there's not a condition that states he's not allowed to use legal substances. And I've spoken with him. He did use legal marijuana. It's available at the store. And that's.
I'm not going to have a hearing on that, but I will have a hearing on it. But his bond is revoked right now for testing positive. We're going to stand by this. I know you want to make a big stand on that because of your presentation, but marijuana, THC is not across the board legal. It's not. It's not. And you can't just say, well, we're going to test positive here and I got to get out of jail free card. And I'm going to drive around town. I'm going to leave here, get in an accident, kill a bunch of people, and then test positive, and then they're going to say, what idiot judge let you loose after you had tested positive here in court? That's it. But if you want to write your name and say, I'm responsible if he goes out and hits some people when he is testing positive here on the test, and I'll accept responsibility for all of that, go ahead. But I don't think that you're going to do that. But somebody's got to be responsible. And the fact of the matter is that I know that there is certain THC that's out there that is has been deemed not illegal.
Right.
But and I also know that because I helped on this bill, and that is medical use of tetrahydrocannabinol,
Right.
Cannabis, and which is not the sativa L, but
What is?
I helped on that. So I'm involved in that, and I know I'm sensitive about people who do need treatment, but that has to be administered through medical expertise. You can't go into somewhere off the street and say, okay, this has got to be legal. I don't think so. I don't think so. I don't think so. You don't know what's in there. You really don't.
We're not judging off the street, not if you're buying it from the corner, but it's available.
Where's he getting it?
From the store. There's lots of stores in, I mean, there's 100 stores in Beaumont that
Okay.
sell marijuana.
I'm not
over
going
the
to,
counter.
that is not a get out of jail free card. We can have a hearing on it, fine,
Understand.
and we'll litigate it. If that's what you want to do, great. That'll be done, but we're not going to set loopholes for people to be running around saying, I'm going to the store and getting out of the store. And so it must be good stuff.
It's all right. I've tried it.
Well, good for you. Well, I hope that if you're not, I hope you can, well, I mean, the point of the matter is, if somebody goes out and kills some people in a car wreck and it tests positive, nobody's going to be laughing about it. There's nothing funny, especially from yesterday when we had decapitation of poor victims, decapitated in a car wreck because the guy was intoxicated.
Right.
Whether it's alcohol or other substances that can foul up your abilities to act responsibly. People, it's not funny with what we have to deal with. There's nobody saw those pictures and think there's anything comical about someone who can get into a 4,000-pound missile and drive around high.
Right. I agree with you 100%, Judge. The only point I was trying to make first was that he failed a urine test, not a blood test. Obviously, in a car wreck situation, it would need to be in his blood to be causing intoxication, not in his urine. But my concern, only, Judge, is just to point out the notice issue. The standard bond conditions that are given to people when they leave the jail, I believe it says don't break the law. It says have an interlocutor ear to DWI and don't go around the victim. The problem here, not just for him, but I think, but a general problem maybe the county needs to address is that it does not state anywhere do not become intoxicated. And it doesn't state do not use legally intoxicating substances. In fact, it doesn't even say don't drink alcohol. So in this scenario, he was using a legal substance and there was no notice for him to not do so in the bond conditions.
Did you drive up here today? Don't look at him. Did you drive your car up here? Did you drive your car?
Mm-hmm.
Yes.
But he's not intoxicated right now. He did fail a blood test. It's a urine test. Urine goes back for a month. If he used marijuana
We
last
can
month,
talk about this at another time.
I understand. I just
Judge,
right now.
maybe, is there a time for a quick docket before trial next week where court could take this up? They would have an opportunity to get whatever it is they think they need to get to put in front
I
of you.
can set it for any time. I can set it for any time. I don't have to do a quick docket anytime.
Well, I think that's what we're calling them now. That's why I'm referring.
What's a quick docket?
It's the ones before trial each week. That's what we're calling them now.
You only give us 30 minutes.
No.
You see what I'm saying, though.
That was my coordinator's idea, which I don't disagree with. But we can't complete it in 15 minutes
Right.
anyway.
Um,
But yeah, I'm sorry, we're gonna stand by our test and y'all can appeal me. We're gonna stand by our test that he is testing for an illegal substance and his bond is revoked and doubled. What's his bond right now, please? I'm not looking him to gamble out of here after I've got a test. That's blood on my hands. I'm not gonna do that.
Weird.
And the test that we use is supposed to be is presumed to be a valid test.
Don't disagree with the test, just disagree that the substance found is illegal.
5,000, 5,000, and 100,000.
Okay. The bond is, your bonds on the two 5,000s are doubled to 10,000 each. And yeah, do you have a drug patch?
He's not have a drug.
You're gonna have a drug patch from here on. I'm gonna treat you like everybody else does, like everybody else is treated who tests positive for substance.
I don't understand.
He'll talk to you.
Yeah, he's not 100% English, so.
Yeah, he'll talk to you about it, but here, my telling that if you're on bond, why flirt with trouble? That's just a foolish. Don't get near that stuff. Even if you think it might be legal, if it's going to be testing positive, why go through this? But I'm going to stand by the tests, but you can beat the rap, but not the ride. I think is a terrible statement because I don't want to take the ride.
No.
Even though it might. But that's just right now. This is still being. They're still navigating, trying to figure out how to sort all this stuff out. And until they do, why would you even flirt with the trouble on bond? I mean, it's just not a wise thing to do. It's like playing Russian roulette. Anyway, that's what we're going to do. I'm doubling those two 5,000s to 10,000. So you're gonna have to post another bond in each of those two cases. That's is a $10,000 amount. Anyway, that's what we're gonna do. All right, on Mr. Hernandez. Okay, and here on you come in, okay, who failed the drug test? Who failed the test?
That was Mr. Hernandez.
Okay, what's Brandon Semino all about?
Judge, that's the one where Jimmy Ham also filed a motion to increase bond on that because he's having contact with the victim.
But John West had the conflict, so he had to get off the case. So you appointed Don, you revoked Mr. Semino's bond and said, we'll reset it to do a hearing on the bond once Don has had a chance to look at it.
Okay,
He didn't say what the bond was.
Brandon Thomas Semino.
That's Mr. Semino.
You are Brandon Semino. You are Mr. Semino, 2240955. Okay. Who is his attorney? John West?
No, Mr. West withdrew this morning because of a conflict because he represented.
And I appointed.
Mr. Dusler.
Okay, Mr. Dusler, then I'm going to appoint Mr. Dusler. I need him back tomorrow. So we can have a hearing on this because a motion has been filed because it is alleged that you are contacting the victim. There is belief, there is reasonable belief that they may be occurring, which is forbidden. You are not allowed to have any contact with the victim because that would be attempting to interfere with this investigation. Until we can resolve this, you are in custody. We're going to have a hearing tomorrow. And if I am convinced that you're not, then you will be released. But there is belief here from the state that is reasonable and probable that you are contacting the victim, and that is forbidden. Do you understand? Okay. I don't want you to say anything until your attorney talks to you. Mr. Dusler is appointed. I'm going to get him up here tomorrow so we can have a hearing on this, okay, and resolve it. And a similar, Arthur Washington,
You need to appoint. I think.
in your case, you have filled out something and I'm declaring you indigent, so an attorney will be appointed. That's you.
That'd be me.
Langston Adams will be appointed. There is also a motion as well to increase your bond because it is alleged here in a similar motion that the defendant is having contact with the victim in violation of bond conditions and holding the children hostage in an effort to get her to drop the charge. If that is true, that is strictly forbidden. And that if that is deemed appropriate, if I believe that's happening, your bond is going to be well, I would revoke it and there would be no bond because you can trying to pressure people who are involved in this case illegally or in violation of your bond conditions is pretty serious because that's why otherwise we wouldn't have a courtroom to resolve problems properly under the law. If you go out and do it behind the scenes and pressure people, then we don't need lawyers. We don't need judges. We don't need rules of law. But that's not the way to handle your problem. When a problem, even if it's personal, becomes a case file, then you lose a lot of the privileges and the special nature of privacy involved in your relationship. And then a bunch of strangers have to come in and resolve the problem.
Just let me set that one Monday, if you don't mind.
Is that what you want to do?
Yeah.
Okay, because he's going to be revoked temporarily until
That's no.
Monday. Okay.
I did speak with her. She's available next week. So
All right.
We can.
Then
do that Monday.
Mr. Washington is held in custody until Monday. We will place it on the docket for Monday to resolve. And Mr. Adams is here representing him and requests a Monday hearing. And I have, again, Brandon Semino's case, I have approved indigency in that case. Anything else?
Yes. Judge, can you give us the amount of votes on?
Hey, what are we doing on Hillary Samuel? I have these, but that was at another time. That was at last month.
Judge, we have,
Well,
Keyshawn Barlow. That's on this doc. I gotta put you right here.
It's this afternoon's docket.
This afternoon, the one, that's it right here.
all right, I don't have that stuff.
No, he has a new murder case that's just been indicted and we need to reset it to give him discoveries.
Yeah, if that's the case, you got at 1:15, if you don't mind, can we just move it off?
Yeah. To win.
So when you feel what you want to do,
I just gotta give him discovery so he can be ready to
3 weeks.
that's fine.
All right, reset
That's
Barlow 3 weeks.
and that's at you 1 o'clock.
Okay.
All right, thanks.
All right, thank you. Anything else? If not, we are in recess. Thank you till 1 o'clock.